The disposition hearing addresses what happens next after this finding of adjudication. Unlike in the criminal context where sentencing might happen weeks or months after the adjudication of guilt or innocence, the adjudication of dependency is sometimes followed immediately in the same hearing by a first dispositional hearing. Why? Because we have to answer this fundamental question: where's the child going to be tonight? It's kind of live work. We need to know where that child's going tonight, where she's going to school tomorrow, who is caring for her today. And that's the fundamental question about disposition. The rules of evidence are looser. The statute is clear that all competent evidence, whether or not admissible, all competent relevant evidence may be admitted to help the court make this dispositional finding. The standard is also clear. Preponderance of the evidence speaks to what the child needs. There's a little speed bump here. If the child's going to be removed from his or her parents' care, the moving party must make that finding by clear necessity. So we ask this basic question: is it clearly necessary to remove the child from his or her parents? Reasonable efforts is a phrase you'll hear often at both the adjudicatory and the dispositional hearing, and throughout the life of a child welfare case. The notion of reasonable efforts is given to us from the federal law. It's a condition of federal financing of these cases. And it asks, did government, did the state or county agency act reasonably in preventing the placement, in preventing the removal, in facilitating the return home, in working with the parent to avoid this placement? It's a very practical question. And so the advocate must ask, both the parent advocate and the child's advocate, is there some reasonable alternative? We all should be asking this question. From a strengths-based perspective, we want to know, is there some dimension of this family life that we can build on? The classic kind of situation is where housing is the issue. And so one might ask, can housing be provided in order to avoid the placement? Through the life of the case, the court and thus the advocates will be asking the reasonable efforts questions. Safety and permanency are two watchwords of the dispositional stage of a case. The very meaning of the business is about the safety of the child. At the core, that child has a legal right to be with a permanent family member. Typically, that's their birth parent or some other person who is legally responsible for them. But safety and permanency are the way to well-being. And that's our real objective, to raise children, to raise them into healthy adults. And so we need to be concerned with all the aspects of a child's well-being. This includes their education, their physical health, behavioral health, even their dental care. We want to know about after-school activities, and we want them involved. Kids in foster care, there's no reason they shouldn't be involved in their local scout troop, or after-school activity, or sports, or chess club at their grade school or high school. We ought to ask them what they want, because of course, just like your kid or mine, we want to make the experience of childhood as normal, as ordinary, and as child-specific as we can. We're representing the whole child as guardians ad litem, as lawyers for kids. However they come to us, we are responsible as a system for the whole of them. We're investing in their future. The work that we do for them today, they will be unpacking long after we're out of their lives. It's a weighty burden. It's an important job. We want it to be fun, encouraging, and delightful for you and for your child client.
And in your new role as a guardian ad litem, one of the tasks that you may be asked to assume will be the medical and educational decision maker for a child. One of the most important parts of that role will be to look at the issue of psychotropic medications that the child might already be on, or someone may be contemplating putting the child on those medications. Should the child be on a medication at all? Well, how can you decide that? You're the guardian ad litem, you're not a medical person. You should ask yourself first, if the child is displaying troubling behaviors, tantruming, hurting themselves or hurting someone else, or if they're depressed, what could be the reason for that? Well, we can assume a few things. We can assume that a child has experienced trauma if they've been removed from their home. So first, one should try all sorts of interventions that have nothing to do with chemicals. For example, one might look at whether the child is missing their parent, their mother and their father, their siblings, whether visits are not quite long enough, whether the visits really need to be supervised or not, whether that child needs some attention to their physical well-being. Are they eating well enough? Are they sleeping well enough? Is there a need for more exercise? Does that child need activities? What's happening with that child at school? Is it possible that the child is being bullied in any way? Is it possible that all the changes in that child's life have led to these behaviors? It's incredibly important to look at all the non-chemical interventions before you say to yourself, an assessment is necessary. If you determine that even after all these interventions, there still are troubling behaviors that cannot seem to be managed, then the next question is, okay, let's have an assessment. And an assessment may lead to a diagnosis. So it's important to recognize in your role as a guardian that it's not necessary for every child to have a mental health assessment. If they have this assessment and a diagnosis is made by the psychologist, the next question is how to intervene then. Again, the next question for you should be, it's not always medication that that child needs. Sometimes what that child needs is intensive therapy. Therapy is really the response for small children, teenagers, any child involved in the system. Medication, unfortunately, is quicker, it's easier, and it's much less expensive, and that often tends to be the recommendation. When a child is in your care as the guardian ad litem, you should then say to yourself, if this child is on medication, why is the child on the medication? Who prescribed it? How long has the child been on it? Is the child experiencing any side effects, weight loss, weight gain? Does the child have a flat affect, unable in any way to communicate effectively what it is that they need and they want? It's very important to see what type of effect they were expecting for the medication from the child, for the child. The next question really for you is, if this child's been on a medication for a long time, is it time to take the child off the medication? And if not, why not? Is that child on multiple medications? Take a look at all of those issues when you come to the court, because the court can order an additional assessment. The court can order that the issues of medication be studied. The court can order all sorts of interventions that may obviate the need for continued medication. You should know that in the nation, everyone is very concerned right now about the number of our children in care that are on medication. Estimates now are 75% of the children in out-of-home care are receiving psychotropic medications, mostly off-label use, and causing grave side effects for children. So when you are acting as the medical and the educational guardian for a child, make sure you understand all of these issues, because when you come into court, the judge is going to want to know.
Know the backstory of the child and the family. So often when we get into the courtroom, we begin with maybe what has brought the child into the dependency system. And that is an important part, obviously, to know. But so often that has had a backstory. It might be the life of the parent themselves. It might be events that have happened in the life of the child before the child even got into the dependency system. And so although it takes a little extra time, maybe as counsel, to learn the backstory, my experience has been that if you make yourself knowledgeable about that, often the solutions come from understanding the backstory. Know the value of the question, why? We describe a lot of behavior, we describe a lot of facts in the courtroom. We're a very fact-oriented system in dependency, but that isn't always the whole story. Asking the question, why would that happen? Why would a parent be addicted to drugs? Why would a parent move 10 times? our presumptions may not always be accurate. Behavior, it doesn't change easily. We know that, even when it's for good. And so transforming behavior is what the dependency system is about. We have to be smart about the way we change behavior. So as a guardian, understanding motivational interviewing, understanding that people don't make change because we tell them they're bad. People don't make change because they already know they've done something wrong. They make change because of their will to do so. And so helping people find that answer and will is really a large role of everyone involved, and particularly the guardian, perhaps. Know and look for signs of grief and loss. Much of what we understood as being bad behavior of children or poor decision-making of parents is not necessarily that people want to act like that, but often their grief and loss, unprocessed, can bring about behavior that looks to us as if they don't care or they're not interested, when in fact they are really suffering from grief and loss that they have not processed. And so again, that ties in with the asking why. Is this about grief and loss? It ties in with the backstory. What has happened to them over a period of time that would bring about this type of situation, bringing them into the dependency system? Also helping the family unload all of their pain and grief, not just the child, but the family can really begin to strengthen everyone and promote the health of that family. Know that when you help the family, you help the children. Sometimes I think the guardian ad litem sees their role as just looking at the interests of the child, and certainly that's the primary interest. But there's no child that doesn't love their family. In my experience, even children who have been physically abused have a fondness and a love for their biological parents and want that relationship to be healthy. And so just taking care of the child's needs and not addressing the family's needs really doesn't promote the life of the child, who needs that bonding and needs as much health within that family as possible, even if it is from a placement in a distance. I think the guardian has a special role to be the mediator. There's no one that has as pure an interest in a dependency case, perhaps, other than the court, hopefully, but in terms of the litigants, than the guardian. The guardian has the interest of the child. And in the end, that's what we're all supposed to be there about. So the guardian really can fulfill a role of playing the mediator and bringing everyone back to what are we here about? And bringing all the stakeholders to the table. They have a great opportunity to think outside the box and be creative instead of people finding their adversarial advocacy and making sure that we all come back to the important question, but how will this help the child and how will this promote the family? Finally, in all of these tips, an overarching goal would be that to always speak the positive first. I think that strengthens the system, it strengthens the family, and it strengthens the child to know that there are strengths there to build on, that we're not just there to tell them what they're doing wrong. And always remember, when you help the family, you help the child.